got a low worth about a half a ticket. Non-swipe convention got him looking at me different. I can't be feeling when I kiss him, yeah. Kidnap you and misses, yeah. Tyson hit him, I was in the slums. Any weather, I was still trapping, sliding on the pussy. They putting cameras on the lights, playing like you stupid dog. You know what I do to you. Hit me from the cell, told me get the cake. I'm weighing up them bowls, hella coke around the digi. Playing with them bloods, they gon' pop you like a skip.
This is case number 21 CF 1848, State of Wisconsin versus Darrell Brooks.
Obviously, I don't need to state Mr. Brooks is facing 5 consecutive life sentences if he's convicted on all counts in this complaint. I wish to notify the court sadly that today we learned of another death of a child related to this case. We do expect a 6th count for first-degree intentional homicide to be issued or added, to this case. There's a number of other charges that we are reviewing and considering, but certainly, at the very least, we do intend to file a 6th count of intentional homicide. I want this court to know, and I think the court has read the complaint, you've indicated you've read the complaint, there are not words to describe the risk that this defendant presents to our community. Not only flight risk, but the dangerousness that he presents, his history of violence, and the allegations in this complaint where it is stated plainly that on several occasions he was told to stop by police officers. They risked their own safety to try and step in front of the car to stop him. Everything was done to get him to stop, and he just simply continued down the roadway, causing death and destruction in his path. So I am advocating for a significant cash bail, Your Honor. I'm asking for $5 million cash bail. I know that's a large amount of money, but I think it is warranted on this history, and I think it's warranted when the court considers, if convicted, Mr. Brooks will spend the rest of his life in prison. Thank you.
Thank you. Attorney Perry.
Thank you, Commissioner. When this court determines what amount of monetary bail is reasonable and necessary to assure Mr. Brooks' appearance in court, I guess at today's hearing, the only thing I would add for the court's consideration is that Mr. Brooks is financially indigent, does qualify for public defender representation, and that individual circumstance must be taken into account.
Does that conclude your argument?
It does.
The gravity of the offenses, the maximum possible penalties as the statute allows for, likelihood of incarceration, which if you're found guilty of 1 or more of these, even 1, would put you in prison for the rest of your life. I believe you are a flight risk. There's failure to follow court orders. This allegation, although the motive is not known, I'm not entitled to know what that is, but it looks like there was either panic or whatever, or an intentional act for whatever reason. You don't do well under pressure. The Milwaukee County case talks about, as Attorney Hopper indicated, you using a vehicle to run over another person with your vehicle. So you don't respond well to what is common sense within our community, our society. I have no problem with the bail being recommended by the state. I'm an old guy who has been doing this for almost 40 years. DA's office, criminal defense attorney, 17, 18 years as a commissioner, both in Milwaukee and now in Waukesha. The nature of this offense is shocking. Actually, the detail I was not expecting here today, that two detectives, not lay people, detectives, not only tried to stop this, but rendered an opinion that this was an intentional act. You're presumed innocent, sir, but that's what the allegations are. And I've not seen anything like this in my very long career. It seems to be a very strong case for the state. Likelihood of incarceration, which is the other aspect of bail, is absolute. If you are found guilty of any one of these, a multitude of them, it's a life imprisonment sentence that must be meted out. So I have no problem. I just, with that bail, it's extraordinarily high, but it's an extraordinarily big case. It's an extraordinarily serious case with an extraordinary history of this gentleman, of fleeing, of hurting people, of not following court orders, not following criminal laws, not following just your societal norms. So I know that that's extraordinarily high bail. It's warranted here, and I am setting cash bail in the amount of $5 million.
And then we'll come back and, of course, address the jury questionnaire issues. Is there anything ahead of that that the parties need me to address or before we break? Attorney Opera, anything from the state?
Just briefly, Judge, I observed that for about the past 40 minutes, Mr. Brooks appears to be asleep in the courtroom. I don't know if he's just being disrespectful, uninterested, or if he's not feeling well. But to avoid a appellate issue in the future, I think it'd be appropriate to inquire if he is capable of assisting in his own defense at this point.
All right, why don't I give the defense attorneys a moment? We'll mute the microphone so they can talk to Mr. Brooks, make sure he's feeling okay, and make an assessment of his ability to assist in his defense during these proceedings. I'll step off while we do that.
All right, and we're going to take a break and then we'll pick this up when we return.
Why don't we do that? That's
Okay.
probably best. I will mute the audio. The live stream will keep going unless the defense wants me to stop it. Mr. Brooks, the live stream is on.
I don't care about no live stream, just like y'all don't care. All this political, it's the show. Y'all been told what to do.
Mr.
Y'all
Brooks,
get paid.
Mr. Brooks, look at me for a minute. Mr. Brooks. Mr. Brooks,
You
look
sit
at
up here and act like you know me. People like you don't, y'all
Mr.
you
Brooks.
don't know nothing about where I come from.
Mr. Brooks.
You push me, dog. Don't push back that.
Mr. Brooks.
Don't push back. Push me in.
Mr. Brooks, we have to continue with this hearing.
I'm worried about, man, don't put your hand on me. dude.
Nobody put their hands on you.
Yeah, they better not put their hand on me.
Okay, Mr. Brooks, you need to look at me for a minute, okay?
Why? To listen to all this political stuff y'all got going on?
Mr. Brooks, I'm more concerned about.
Don't touch me, dog. They see it.
All right, we're gonna take a break and we're gonna come back after lunch. I'm not gonna do this with him right now. He needs to be here. He's not cooperating. Give you the warning, Mr. I will give you the warning that if you continue to interrupt when we go back on the record, you will forfeit your right to be in the courtroom today. I can't have these interruptions. I want you here. It's been a long day and a half.
Keep your hands off me.
We'll come back at 12:30.
Just told you to get off me.
Mr. Brooks is competent to represent himself and waive his right to an attorney.
Quick
I think
objection.
it all, Mr. Brooks, you're not, don't interrupt me. It also helps explain some of the interruptions.
That's a rest
and-
judgment, Your Honor.
Not right now. You can ask when I'm done. It also, I believe,
I
helps.
object.
Mr. Brooks, let me get through this. It's really important that I make a record and honor your request
I understand that.
to
I don't understand
represent
why-
yourself.
I don't understand why.
Mr. Brooks,
um,
I'm going to explain the
something-
relevance. So
I
just
don't-
stop
I don't
talking and listen to
understand-
me.
I don't understand why something pertaining to a plea that is not standing anymore has relevancy to the decision that's being made right now, months
Stop
after.
talking and listen, because you're gonna get the answer. okay?
Okay. I hope so.
Frankly, statements like I'm informed or I'm aware are the functional equivalent of you saying I understand.
I don't.
I
object to
cannot
that.
say that this is one of those
Everyone
narrow
said I
class of,
understand.
Mr. Brooks,
I
stop.
object, which is my First Amendment right to be able to say what I want.
Mr. Brooks, your rights do not involve interrupting me. That's the,
I objected. I didn't
that's the
interrupt. I
procedure
interject.
that we will
Object.
follow. At trial, what's going to happen if you continue to do that is you will be admonished in front of the jury
That's
if
fine.
you continue that.
That's fine.
Mr. Brooks, we're having issues because of you.
We're having issues.
Not because of me. I've made my determination. I provided you with the law.
I'm not gonna let you intimidate me into believing
Mr.
something.
Brooks,
that
I am
know
not
is true.
intimidating you.
Because you can't, and you see that.
Well, then don't.
You clearly see that you can't intimidate me. No, I'm not.
All right, then you will participate. I'm going to start jury selection.
No, I will not. I'm not consenting to anything you say until you can answer the questions that I'm asking.
He is, by his conduct, not the choice of the court,
No, that is judicial
He is-
misconduct of anything, Your Honor. I simply merely
going to
asked
be
for
in the other
questions to be answered.
courtroom for jury selection. You can take him back there. He has repeatedly interrupted this court. He has refused to follow the most simplest of standards despite being given the rules of courtesy and decorum for the courts of Wisconsin. Again, Mr. Brooks, I absolutely want you present in the courtroom, but that is for you to decide at this point. Would the bailiffs please remove him to the other courtroom? This court is on day one. It is 2:15 p.m. This court, within 5 minutes of starting court this morning, had to remove Mr. Brooks based upon his interruptions at that time. I've lost track, but I think I'm at least 5 or 6. Who knows, maybe more. We have this amazing technology. The case law hasn't caught up to that technology. I believe this court can continue to go forward in this fashion with Mr. Brooks being in the courtroom next door.
Darrell Brooks, now representing himself in court, spent most of the first day of jury selection removed from the courtroom for his outburst and disruptions. Nevertheless, the court was able to make some progress towards the needed jury of 12 with 4 alternates. It was November 21st, 2021. Thousands of people were gathered in downtown Waukesha, Wisconsin for the annual Christmas parade. But an afternoon of holiday cheer turned into a tragic nightmare. Police say this man deliberately drove his SUV into the parade.
It increases its speed and it begins to do a zigzagging motion through the crowd, hitting people, running people over, and it appears that the vehicle's intentionally aiming for people.
The alleged driver, Darrell Brooks, drove through the parade route for 5 blocks, driving up to 25 miles per hour while plowing into parade goers and participants. Detective Thomas Casey was working that day and testified about what he saw at a pretrial hearing.
I first stepped in front of the SUV, put my hands up, and was yelling for the vehicle to stop.
Okay. Did the vehicle stop?
It did not. It first hits drum player, it continues, and I would say it hits approximately 10 people and runs directly over the top of them, and then turns to the right and starts hitting other people in the parade route.
Dozens of people were hit. 6 people died from multiple blunt force injuries, including an 8-year-old boy, and 61 others were injured.
These families are going through a really hard time. Everybody that was here just went through such trauma.
According to the criminal complaint, the driver slowed down only to then accelerate, taking an abrupt left turn directly into a crowd. This, investigators say, showed an intentional act to strike and hurt as many people as possible. The driver didn't stop until a police officer shot at him.
One of our officers saw the vehicle coming at him and forced that officer to discharge his service weapon.
He fired at Mr. Brooks' vehicle?
Yes, he did.
Did he strike the vehicle?
3 times.
Did the vehicle stop?
Did not.
Brooks eventually drove into a nearby neighborhood, crashed his car, and then took off on foot. He stopped at this house where a Ring camera captured the moment police caught up with him. Brooks was arrested and charged with dozens of criminal acts, including 6 counts of first-degree intentional homicide. Interrogation records from that night show Brooks told police that he, quote, didn't mean to kill anyone. Brooks pleaded not guilty by reason of insanity, but withdrew that plea in September.
Have you had the opportunity to thoroughly discuss your decision to withdraw your special plea with your attorneys?
Yeah.
Have they discussed the advantages and disadvantages of withdrawing that plea with you?
Yeah. I have my own reasons why.
Just a week before trial, yet another twist in the case. Brooks decided he would represent himself, prompting his defense attorneys to withdraw. At a hearing, the judge ruled Brooks competent enough to represent himself, but his actions in court are raising questions.
I object to that.
His responses to questions asked.
I object to that because at the end of the day...
I understand, Mr. Brooks, stop. You can object. Your objection is noted. I'm going on. This is one of the expectations that I have, is you can object. It will be noted, but you can't keep interrupting.
You're
your
reading
objection, sir, your objection is noted.
You're reading from something that I haven't been privileged to read myself.
This is a prime example of some of the difficulty with Mr. Brooks.
I don't think you have a PhD, Your Honor.
He can be, in my opinion, deliberately disruptive, but nonetheless, he maintains being competent at the most basic level in order to present a defense on his behalf.
Object to that.
Brooks' mother pleaded with the court not to allow him to represent himself. She says she won't be at the trial and expects her son will be out of control.
And I hate to say this, you're going to see manic, full-blown. That's what you're going to see.
With the Secretary of State.
I provided you yesterday as a courtesy with a copy of my oaths of office. My name is on that as well.
They were not certified.
You are attempting to disrupt with asking questions like this.
I am not.
I realize it may very well be related to your claim to be a sovereign citizen and disputing the
claim to be sovereign. That's correct.
Jurisdiction of this court, but these are not questions this court is obligated to answer.
I would like to correct the record and say that I am sovereign.
All right, you believe you're sovereign. The record is corrected. So, Mr. Brooks, we're getting really close for you crossing the line.
Really close to crossing the
line,
line,
removed from the courtroom for continued interruptions.
I
want you here.
To that, Your Honor.
Mr. Brooks, you haven't let me get in one sentence this morning. It is only, it's 8:57. I want you to be here. Certainly my preference is for you to be here to participate fully, but you do not have the right to disrupt the proper administration. I demand dignity, order, and decorum. Everyone here has been respectful other than you throughout these proceedings.
I object to that respectfully. I have not been disruptive, and I do not see any paperwork that you just described to be in front
Mr. Brooks,
of me.
I'm going to continue with a finding right now that you have flagrantly disregarded elementary standards of proper conduct. That conduct will not be tolerated. You stating things even in a mild manner tone of voice doesn't change the fact that we've had a dozen or more interruptions by you and by you alone. When you don't like the answer I give, even if that's a non-response, you continue to ask the same question over and over. You repeat yourself. You show absolutely no respect for the court, but the next interruption, you will be removed to the next courtroom.
I do not consent to any paperwork that is not based factually in law. I don't give my consent.
We have the jurors here?
And I will not agree to anything.
Not yet, okay.
So again,
Your Honor, just from the
with that title, I object respectfully. With that title name that is on your card, since you will not answer the question that I've merely asked of Your Honor numerous times at this point, can that title name please direct the prosecutor to answer whether there are any more charges? Can the title name please direct the prosecutor to answer whether there are assessment for the charges
Mr. Brooks,
in her possession?
no one's going to be answering these questions, okay? I'm not requiring the state to do that. I'm advising you to stop asking those questions. It will be considered an he's interrupted. Take him to the next courtroom. I'll make more findings when he is in the courtroom next door, and I can do that without an interruption.
Or agree to a estoppel, and I will move the court again.
Currently, you are not muted. All right, Mr. Brooks? All right, you can mute him. All right, Mr. Brooks, you have been muted so that I can make some appropriate findings here this morning. I understand that you object. Your objection is noted. Your lack of consent is noted. As I indicated earlier, I lost track after about a dozen or so interruptions by Mr. Brooks. He continues to ask questions that I told him I would not answer. He has failed to follow the simplest of procedural requirements. He continues to be in the other courtroom. You can see on the monitor, he's standing, he's facing the other direction. He's yelling what, I can't hear him, but it appears that he is yelling. I muted him because of his interruptions of the court, and I understand he objects. His objection is again is noted. And because of the disruptions, and based upon the authority in Illinois versus Allen, I also referenced yesterday a persuasive case. It's not at my fingertips. I'll get that for the record. It's the Pennsylvania case that I found to be of persuasive value, where a similar procedure was done. Frankly, what we are providing here in Waukesha County through the use of the technology we have in the courtroom is far superior to what was done in that Pennsylvania case. I have the ability to mute, to unmute. I can see him. He can see the 4 cameras in this courtroom right now. That would be me. It would be the table where I would like him to be seated. That is empty, the prosecution table, and then the witness stand. I will instruct the bailiffs over there to give him a pad of paper if he doesn't have one already. I know he had some documents and some things in front of him. At one point, I saw him sort of do a sweeping motion, and things seemed to go flying. I'll get some verification of that from the bailiffs who are over there through the bailiff that is in my courtroom. But he will at least be given a notepad, a writing utensil. He is advised that should he want to raise a strike for cause of any juror, my procedure is to address that at the end. Certainly if something comes up before that and he wishes to do that under the law, he can simply write on the pad of paper he has cause, hold it up, and I'll make a determination if I should excuse the jury and then take up that decision.
I know that the defendant made 2 motions to dismiss for judicial misconduct. Again, I'd ask the court to summarily deny those motions based upon lack of merit, and he didn't provide support for either motion.
I believe he did raise a motion to dismiss based on judicial misconduct. I think he also threw in there another request to stay the proceedings or file an interlocutory appeal. While that's really not something I would need to address because nothing's been filed as it relates to a request for an appeal, I will deny that summarily. There's been no basis in law or fact provided. I'll also deny the motion to dismiss based on judicial conduct, based upon there being no showing in law or fact. It appears to me that Mr. Brooks continues to stand, make hand gestures, and talk. I will, again, just advise him, should he desire to raise any issues with the court, he is advised to write that down on paper. The bailiffs are instructed to promptly provide that either to the court staff that's in there or another bailiff, and that will be provided to me forthwith so that I can raise any issues of merit. All right, with that, then we will begin the jury selection process, and so we can go ahead and bring them in. All right, we are back on the record. Mr. Brooks, I was able to inquire. I've been told it would take maybe 15 minutes, but I'd like you to go to your cell to get whatever that list is that you have so that I can adequately advise the jury, potential jurors, about any witnesses who may be called in this case. I don't designate when I say if it's the state or the defendant, but you told me you have that, so I'm going to give you that opportunity. In the meantime, I'm going to print off the state's witness list.
I don't need it.
Now, you also mentioned previously when I referenced going back to your cell to get the list. I'm giving you that opportunity. You asked me to do that.
I did not ask you to do that. The question was, where was the list at?
That's true. So you said the list was in your cell. I'm advising you that I'll give you the opportunity to go.
I don't want to do that.
Can I finish? I'm advising you that you are being given the opportunity, if you so choose, to go back to your cell to obtain the list of witnesses that you have been working on. Further advising you that if you choose not to do that, either tell me now or write them down so that I can include them in the list of names I'm providing to the jurors.
So how am I supposed to do that without the list in front of me?
The list that you have in your cell?
How am I supposed to do that without the
I'm
list?
telling you, I'm giving you the opportunity to go get that.
I'm not
So,
going to go do that.
Mr. Brooks, I'm not going to play games with you.
And
I'm giving you an opportunity.
And I told you that I'm not going to do that.
You either go to your cell and
You
get
said
the
I have the
list or
opportunity
not.
to do that.
All
You
right.
said I have the opportunity.
I'm not going to
do
demand that you do it, but you have to understand, sir, that if you
I
choose
don't
not to
understand.
do that.
I don't understand. I don't understand.
All right,
I've
Mr.
made
Brooks.
that clear. I don't know
You
how
claim
many
to not
times for the
understand,
record.
and that's been made very
Oh,
clear
I don't
here, sir.
understand. You're not
So-
going to get me to consent to something that I don't consent to or agree to. I do
No.
not
All right.
understand. Just
Mr.
like I
Brooks,
don't
we're gonna
understand the
take a
nature and
recess
cause
so
of
that
this.
the court can get this
Exactly
information
like I've
from
been
the
telling you
state.
from the beginning.
Okay, he's continuing with his disruptive behavior. It is his choice to do that. Mr. Brooks, you are hereby warned, once again, if you continue with that, you will be removed from the courtroom.
Remove me. Remove me.
Requesting to go to the other
Remove
courtroom?
me. I told you that before I even came over here.
Sir, are you requesting to
I
go?
told you that before I even came over here.
Mr. Brooks, are you
That
requesting?
It was pointless of me to come over here. You can smile all you want and think
Sir,
it's funny. I don't take this as a
preference-
joke. I don't take this as a game.
My preference is for you to be
You
here.
expect me to answer all these questions that you have for me, Your Honor, but you have yet to answer one question that I've asked you. You have yet to verify anything
You
by
can take
sworn
him back to
affidavit.
the other room.
You
He's
haven't
been
even honored-
disruptive.
You haven't even honored my request to make an offer for my appeal.
Thank you, ladies
You
and
haven't even
gentlemen. We'll
honored-
have to
you haven't even
clear
done
the
that.
courtroom.
I don't agree to a estoppel, and I move this court for a motion to dismiss.
The record should reflect
The record should reflect that my rights are being trampled on. The record should reflect that I don't agree to an estoppel. This is ridiculous, man. As soon as I raise the issue, I'm being disruptive. I'm intentionally trying to be disruptive. I'm intentionally doing this. I'm intentionally doing that. So I should have just stayed over here, which ain't even legal to do anyway. Can't be present and not present, when it should be a motion. This is ridiculous, man. This is ridiculous.
Okay.
You're forcing somebody to agree to something that they ain't agree to. Y'all come up with anything y'all can, man. Anything y'all can, huh? Why I need that in here? You could have left that over there. I'm going back over there anyway.
Just in case.
If I'm right here in front of her face, I ain't gonna have no problem hearing it. That's why these could have, I'm gonna have to go back over there. Y'all know that.
We'll bring it with us if you.
I'm just saying, man, this is ridiculous, man. This is ridiculous.